Hello, welcome once again to Lehto's Law. I'm Steve Lehto. I was doing some research on another topic regarding the Supreme Court and arrests and so on. And I found a case from a couple years ago that I think many people missed when it crossed our radar. And it's a fascinating case because, again, the Supreme Court has done something I think most people would disagree with. But the Supreme Court, and this is just 3 years ago, said that police may use evidence found after an illegal stop. Okay, so what we're talking about, and this is one where we have to keep the terms very, very clear. If the police stop you and then they hang on to you and then you wind up getting arrested, there's actually three things happening. There's a stop, there's a detention, and an arrest. Okay, and a lot of people say there's a blurred gray area there in the middle. At what point does it become an arrest? What point does it become a detention? What point is it a stop? But here's the issue: if the police stop you illegally, they have no reason to stop you at all. They have no reason to stop you at all. In the old days, if they stopped you for no reason, they had no right to stop you, and they then uncovered something during that stop that would incriminate you in a crime, the courts had ruled that they could not use that evidence against you because it was the result of an unlawful stop. Well, the Supreme Court said time we should change our minds on that, I guess. And bizarre case. Like I said, the Supreme Court ruled in 2016 that evidence found by police officers after illegal stops may be used in court if the officers conducted the search that found the stuff after learning that the defendants had an outstanding arrest warrant. So here's what happened. This is a case, Clarence Thomas wrote the opinion. It was a 5-3 vote. And he said that these searches do not violate the Fourth Amendment if there is, in fact, a warrant that they discover later for the person who was stopped. And it doesn't matter if the warrant has nothing to do with the stop. So in other words, there's someone just walking down the street. Cops go, I want to stop that person and just see what's going on. They stop the person for no reason. And they determine that, check it out. This guy's got an outstanding warrant for his arrest. So now they can arrest him for the outstanding warrant. And then, of course, they can find other stuff on him and say, well, even though this all sprang from an unlawful stop, Clarence Thomas and other justices said, well, there was a warrant out for the guy's arrest, so that kind of makes it all even. And as you can imagine, the other side had a fiery dissent, which we'll talk about later. But the case is Utah versus Strife, and it arose from police surveillance of a house in South Salt Lake based on an anonymous tip of narcotics activity. By the way, I'm skeptical anytime the police claim they got an anonymous tip. Because as you can imagine, they can just say they got them. Yeah, got an anonymous tip. Prove I didn't. So they said they got an anonymous tip, and a police officer stopped Strife after he'd left a house based on what the state later conceded were insufficient grounds, making the stop unlawful. The officer then ran a check on the man he'd stopped and discovered a warrant for a minor traffic violation. He arrested Strife on that and then searched him and found a baggie containing methamphetamines and drug paraphernalia. The question for the court was whether the drugs must be suppressed given the unlawful stop or whether they could be used as evidence given the fact that there was an arrest warrant, even though they didn't know about that when they stopped the guy. The officer was at most negligent, Justice Thomas wrote, adding that there is no evidence that Officer Fackrell's illegal stop reflected flagrantly unlawful police misconduct. You see the implication there. As long as the unlawful police misconduct isn't flagrant, it's okay. Chief Justice John Roberts and Justices Kennedy, Breyer, and Alito joined the majority on this one. And in the dissent, it was Justice Sotomayor who said the court had vastly expanded police power and pointed out that this case tells everyone, white and black, guilty and innocent, that an officer can verify your legal status at any time. Says that you are subject to invasion while courts excuse the violation of your rights. It implies that you are not a citizen of a democracy, but the subject of a carceral state just waiting to be cataloged. I'll admit I'm going to have to go look up what carceral means. C-A-R-C-E-R-A-L. I'm assuming it comes from the same root as incarceration, suggesting that it's a state that likes to lock people up, or perhaps that you are locked up at all times. You are not as free as you think you are. The court holds today that the discovery of a warrant for an unpaid parking ticket will forgive a police officer's violation of your Fourth Amendment rights, she wrote. Do not be soothed by the opinion's technical language. This case allows the police to stop you on the street, demand your identification, and check you for outstanding traffic warrants, even if you are doing nothing wrong. If the officer discovers a warrant for a fine you forgot to pay, she continued, courts will now excuse his illegal stop and will admit into evidence anything he happens to find by searching you after arresting you on the warrant. And Justice Sotomayor added that many people are at risk following this ruling. Federal and state databases show more than 7.8 million outstanding warrants in America, the vast majority of which appear to be for minor offenses, such as in Utah, where there are 180,000 outstanding misdemeanor warrants. And it's ugly. Justice Ruth Bader Ginsburg joined most of her dissent, along with all of a separate dissent from Justice Elena Kagan. But Justice Sotomayor reserved her most personal reflection for a part of her dissent, in which she wrote only for herself, setting out in detail the dangers and indignities that often accompany police stops. For generations, she wrote, Black and brown parents have given their children the talk, instructing them never to run down the street. Always keep your hands where they can be seen. Do not even think of talking back to strangers, all out of fear of how an officer with a gun will react to them. So, Justin Driver, a law professor at the University of Chicago, said Justice Sotomayor's dissent was remarkable. It's interesting, but again, what we're getting at is this is and was a major shift in the law. And if you think about this, the police have got a lot of power. And people will comment below, I assure you, by saying, yes, they've got a badge and a gun. And they have the legal authority to do certain things, but because they have a badge and a gun, it's actually a different kind of authority. Because if a police officer walks up to you, even if they're in the wrong, you recognize that the badge and the gun and the ability to arrest you or shoot you means that you should probably play along with them. And so a lot of people wonder what happens when they overstep their bounds. And so one of the things that we had, which we used to keep them in check, was the courts. And so if the police did something wrong and got some evidence they shouldn't have through some improper process or an unconstitutional action, the courts used to say, well, if we let them use that evidence against somebody, we're incentivizing them to continue doing this kind of behavior. And the courts want to disincentivize that behavior. The courts want to keep the police from doing unconstitutional things to citizenry. Or just people, actually. If you read the Constitution, it says people, okay? So if you're a person, you've got rights in America. Now, if the police do something wrong and the courts stop it, then maybe the police won't do it wrong in the future. But here the Supreme Court's saying, well, you know something? They can do a stop wrong, an unlawful stop. Both sides conceded that this original stop was wrong. They stopped this guy for the wrong reasons. And like I said, in the old days, everything from that point forward pretty much would have gone out the window because of that unlawful stop. And the Supreme Court in this case has said, you know something, we're going to change the rule. If they stop somebody for the wrong reason, but it turns out there was a good reason to stop them, if they'd only known that the person had an outstanding warrant, for instance, then we're going to forgive everything they did before that. And again, as the justices are pointing out in the dissent, and I think this is true, what's going to happen now is the police are told, oh, if you stop somebody for good reason, you're good. If you stop somebody for bad reason, if you can justify it later, you're good. And by the way, simply looking for an outstanding warrant, play the odds. There's a lot of them out there. And it leads you to the next obvious step. You can just stop anybody. Run their name, see if they've got a warrant on them. And in the old days, they couldn't do that because you'd say, well, you can't just stop people. That's wrong. That's an unlawful stop. Except now the Supreme Court says it's okay. So again, I know people out there are going to say, Steve, Supreme Court doesn't make law. They just rule and interpret things. Yeah, but this is now the law. And so what's going to happen is if they stop you wrongfully, but you have a warrant for you and they wind up using that as the excuse for the detention and the arrest, and then you go into court and try to fight it, the other side's going to say, well, Your Honor, in the case of Utah versus Strife, and they'll cite this case, that is now a rightful stop, not a wrongful stop. And a court's going to say, yeah, I guess you're right. So you can argue all you want about what role the Supreme Court has, but I'm just being pragmatic here and letting you know that they've ruled on this, and that's what the situation is now. So in America, you have a Fourth Amendment right against unlawful searches and seizures, but the Supreme Court has ruled that it is not an unlawful stop, and therefore the stuff that flows from it is perfectly admissible in court, despite the wrongfulness of the initial stop. So crazy law, 3 years old, from the U.S. Supreme Court. And by the way, there's a really strange thing, and this is human nature, I think. But people tend to look at things they disagree with and go, okay, that's the other side's fault. And they look at things they agree with and they go, oh, that's our doing. We can take credit for that. And the funny thing is, in the last 3 days on this channel, I've been called both a Nazi and a liberal. I had somebody actually send me a note and say, Steve, you are such a right-wing Nazi, I can't watch you anymore. And I had somebody else go, you're just a liberal snowflake, I can't watch you anymore. And I got those comments within hours of each other, just a couple days ago. And I always joke with my friends and say, it's kind of funny that I'm a snowflake, liberal, right-wing Nazi. But what's really going on, and I understand this, it's human nature. People who disagree with me assume I'm whatever they're not. People who agree with me assume I'm what they are. But I've never actually come on here and said, by the way, here's what I am. And I try not to take positions that are so crazy that, people are say, oh, he's one of those guys who screams and yells on YouTube. But what's funny about these cases, when I talk about these cases, and by these cases, I'm talking about Supreme Court cases, for instance, is that I'll get people who don't know that much about the makeup of the Supreme Court. And I'm going to get a lot of people going, well, this is what happens when liberals run the Supreme Court. And I know many of you know this, but Clarence Thomas is like king of the conservatives. He is as far to the right as you can get without breaking the meter by pushing the needle past the peg, okay? And this is my right I'm pointing to, okay? And your right would be that way. But this is actually a conservative mindset that police powers are good and law enforcement is good. And what law enforcement does is by its very nature then good. And therefore we should do everything we can to excuse what they do. And I'm not saying that that's right or wrong that they do that. I'm just letting you know that if you want to put this on a political spectrum, you have to put it where it belongs and recognize the fact that Clarence Thomas and the people who sided with him are on the conservative end of the spectrum. And as long as you recognize that, just understand that's what's going on here. So don't post comments below unless you're trying to be facetious or ironic and say, this is what happens when liberals run the Supreme Court, because that's not what happened here. But once again, in case you missed the summary, the police can stop you wrongfully, but justify it later, for instance, if you had an outstanding warrant that they found out about after they stopped you. And that will lead to people being stopped for no other reason than just to see if they've got warrants. Who are you? What's your identification? ID yourself. And we've already talked about stop and ID laws. So there you have it. U.S. Supreme Court 3 years ago. Questions or comments, put them below. Otherwise, talk to you later.